There has been so much of delays that the purpose is lost. Some states, as we know, have been very active, whereas there are some states, especially on the northeast side, who have just not got their act together. Specialization comes by you're practicing in a particular jurisdiction. The financials are bad and the reputation is not good at all. I think then you need to go to NCLT. If you see the project is almost 80% complete and it's just a little bit push which is required, then you go to the regulator. The orders of Karnataka will not be binding on the Haryana RERA.
Hi, welcome to the Property Show. I'm Jayashree Kurup, I'm editor MBTV, and today we're talking about how you can navigate the ins and outs of the legal framework. Today we have Upendra Nath Sharma, partner, JSA. Thanks, Upen, for joining us.
Pleasure.
Upen, how do you see this changing real estate landscape?
The normal courts have always been there. Consumer Protection Act has been there for ages, about almost 3 decades plus. And they were not able to achieve the purpose for which the Consumer Act was got. However, in due course, what happened, there has been so much of delays that the purpose is lost. And with the new real estate mushrooming, the way the industry is growing, something was needed to regulate that. And that is where the government felt the need and got the Real Estate Regulation Act.
Right. Now, the fact that it's a national law implemented locally in the states, that makes it even more complex.
Real estate is part of the concurrent list as per the Constitution. So the central has the power as well as the states have the power to regulate it. And some states, as we know, have been very active, whereas there are some states, especially on the northeast side, who have just not got their act together. Nothing has been implemented.
How nimble do you have to be to get understand the ins and outs of these new laws?
Any law, whether it relates to SEBI or the Companies Act which changed in 2013, you have to be upbeat about it. You have to refresh your knowledge. You're as good as a fresher lawyer coming from the law school. Right. Thereafter, your specialization comes by you're practicing in a particular jurisdiction.
Right. Has the education system for lawyers also taken cognizance of this?
Practically, what we are taught in the law school is really not how you implement it in practice. On the real estate side, there's still, the standard transfer of property act, which is taught in the law schools, and maybe some off courses or online courses in terms of the RERA bit. Mm-hmm. But it's not hardcore focused subject.
How does a consumer navigate this, and how do you find the right lawyer to represent you?
So you see, there is, a plethora of laws here. It varies from each case to case basis. So if your builder or the project are going fine and you are pretty much sure of their credentials, their net worth, their reporting to the registrar of companies, their filing of accounts, you just concept of buyer beware. So just do that basic diligence and you will understand how good or bad this project or the builder is.
In a post-RERA world, I think the present and the future are more or less sorted. Yeah. But the historic legacy of problems that we have.
If somebody is in doldrums, then the financials are bad and the reputation is not good at all. I think then you need to go to NCLT to get your, because then you are just seeking recovery of your money. Right. If you see the project is almost 80% complete and it's just a little bit push which is required, then you go to the regulator, which is the real estate regulator, which is a specialized subject regulator, unlike the consumer court, which has to deal with all kinds of laws.
So it's a speedier justice.
It is a focused and speedier justice.
50% of the consumers want their houses. The other 50%, which was about investment, they want their money. How do you as a lawyer advise them?
The Union Ministry of Urban Development needs to provide some guidelines. Maybe if so much of the project is developed, say 50% and 50% of the people are wanting it, on humanitarian aspects, you should focus getting the project upbeat. Right. Recently, the Haryana RERA came up with the regulator said, if 40% is done, then there's no point of refund. That's a good humanitarian thing. But strictly speaking, there are other RERAs in other states who say, no, the law does not provide us that much of flexibility. Yeah. It just is either this way or that way.
If I see that Karnataka RERA has given an order, can I in Gurgaon invoke that?
The orders of Karnataka will not be binding on the Haryana RERA, because these are each state has its own legislation.
So they cannot be quoted as a precedent?
They can be a kind of a influensive value, but not a binding value that you have to follow that.
Sure.
But say within the state of Haryana, it can be.
Now this needs to be passed in Parliament again? Or does the ministry have the wherewithal
No,
to...
so you see, that's why the Parliament has passed the basic legislation and has given the appropriate government, which is the state governments, the power to rule on it, and even the constitution allows it. So this can be done at the state level by respective state governments.
State governments have to do, or the national government?
No, Union Ministry can provide guidelines, which then have to be implemented by all the states to bring in uniformity.
Do you think that lawyers need to acquire specific skills to handle this?
If you are qualified, you've done your law degree and registered with the Bar Council, you are entitled to practice anywhere in any court of law in India, including tribunals, etc. So that is not required. If you really need to specialize, just be in that forum every day.
Let's take one case that has kind of hit the headlines and remained in the headlines for a long time. It's the Jaypee case. Landmark because for the first time the consumer became a secured financial creditor,
Yes,
right?
Jaypee became a landmark because of that. Then that's where the Supreme Court felt that the poor home buyers are left high and dry. They are nowhere as in the list of creditors. So pursuant to that, then an amendment came to the insolvency code, and they were brought in as creditors, and they have the financial creditors, and they have the right to participate in the proceedings of the creditors committee, take decisions.
Does it seem that NCLT probably is not the right forum for something like real estate, where the numbers are very large, 25,000
That's
buyers?
Right. In fact, it's not only the number of buyers, but there's some fundamental concepts involved here. Flat buyers defaulted in his installments, which led to a default in the whole system. And the builder kept asking for money for a few months, a year. Finally, he terminated. At the outset, we say builder is at fault. Please appreciate, he is to get so many approvals. There's no single window system as yet. And the government takes its own time in giving those approvals.
If the consumer has defaulted on a delayed project, does the same norms of penalty hold?
Yeah, as per the act, they're supposed to pay penalty, and it has to be the same rate of interest which the home buyer is paying him. If for the amount of delay, he has to pay the interest.
And that's MCLR plus 10%,
yes,
right?
Yes, absolutely. And also, state has to appoint an adjudicating officer. Now, that's again a thing which has not happened in many of the states, where despite RERA being implemented, the adjudicating officer has not been appointed. A job of adjudicating officer is to calculate the interest component, or the compensation in whatever form.
Does the role of the adjudicating officer in RERA and that of the NCDRC officers, do they overlap?
This is only to calculate compensation under RERA. The consumer court has been there for long, and their focus is mainly to compensate you. Whereas RERA is not only compensation, but also to ensure that the project goes ahead. The scope and the contours of RERA are much wider, much broader than what is under consumer protection.
In today's world, especially in the Delhi NCR region, where we have so many defaults, so many consumers, all these consumers only bought a house. Today, they're paying their rent, they're paying the EMIs, and they're also paying a lawyer's fee.
Yes.
And many of them are at breaking point.
Yes.
Do you see any resolution here?
See, as a standard norm, a litigant has to pay for his own litigation.
Yes.
Okay. Under the Civil Procedure Code, there is a system of suing as pauper. I have no money, please help me, I have to get this litigation, and I don't know how, if at all anybody follows that route, but that there is a provision under CPC. But so far as RERA is concerned, NCLT is concerned, consumer courts, there is no such provision. If you go to a regular court of law, there will be ad valorem stamp, court fees payable, stamp duties implications, whereas that's not there under RERA. And even under, even if there's some procedural fee that's very nominal, which is not so hurting, even in consumer courts, NCLT has some fees, but those are nominal. And having said all this, there is something called legal aid cells. These are sponsored by the government largely, or the bar councils, and so you can approach them, they can help you out. But again, there the quality of lawyers is not so great.
Right. And the fact is that these are new laws and they are being interpreted and you're coming to terms with them. And the one generation of consumers are actually struggling to pay the fees while laws are being interpreted.
That's the unfortunate part.
Thank you for joining us. I'm Jayashree Kurup. Please subscribe to Magic Bricks on YouTube and click the bell icon to get new videos.